All right, next on the docket is Thorne versus Citizens Property. Let me ask, since we have two related cases back to back, did you all discuss how you wanted to proceed on this?
We didn't. I was going to approach that with the court and find out what the court's deference and preference was on that.
All right, are you all able to do the arguments together?
Consolidate, yeah.
I think we can consolidate.
Okay, and how much time? Still 20 minutes, or?
If I could just reserve an extra 5 for rebuttal, that would be great.
All right, so you want a total of 25?
Yes, please.
That's fine, yeah.
Okay, then we'll go ahead and argue both cases together, and I'll give 25 minutes aside. Okay.
Good morning.
Morning.
May it please the court, my name is George Vaca. I'm with Vaca Law Group in Tampa, and I have the privilege of representing Mr. and Mrs. Thorne in these appeals. We're here today on the first appeal, asking the court to reverse the judgment that basically imposes a specific performance remedy upon my clients.
Let me ask you this as you get started. As I read State Farm versus Phillips, that case appears to be directly on point with what we have here. How do you distinguish the Thorne's case from the Phillips case?
My recollection, Your Honor, is that wasn't really a breach of contract case. I know the court talked about recognizing that State Farm in that case used the statutory permissive vehicle by putting that provision in the policy.
And that provision was in the Thorne's policy, correct?
Absolutely, absolutely. And I think really where we come down on this, so there are several different areas of difference, but as it pertains to this particular one about whether or not this provision applies in the litigation setting, we would ask the court to take a look at a couple of things. First, the Supreme Court's decision in Warfel. Second, the Supreme Court's decision in Johnson versus Omega. And third, just the title of the statute itself. If you look to 627.707, which is the statute that they're relying upon, the statute's title is Standards for the Investigation of Sinkhole Claims by Insurers. It has nothing whatsoever to do with litigation. It doesn't mention at all judgments. It doesn't talk about Chapter 55. And the Supreme Court has twice now said, recognizing not exactly this provision, 707 subsection 5, but has twice said these statutes go to the procedure of claims handling. They don't involve litigation, and they don't involve courtrooms.
Let me ask you this. Would you agree the case law is against you if the damages are less than the policy limits? Is the case law pretty clear? You know, I know you're raising new arguments, but as far as past case law, that there's two options. You know, the insurance company can pay the money, or it can insist on a contract being entered and to pay as it goes along. Would you agree with that?
I think there's all of the case laws, most certainly in the Second District Court of Appeal, is clearly against me on that issue.
And you know, and arguably Phillips as well. But here's a little different situation. The damages the jury found are in excess of the policy limits.
Correct.
Now, they alleged in their brief that, you know, prior to trial, they offered to pay the repairs even if they exceed the limits. But you know, you argue in your brief that they didn't say that after the trial. And, you know, where are we on that? Because I know, you know, in the Ringelman case, we had a situation, which I think is the only case that I saw where the damages exceeded the policy limits, and the insurance company attorney got up at closing argument and said, we'll pay the repairs. I mean, is that where we are now?
Well, actually, they didn't say that. They didn't say that in closing argument. They said that in oral argument before this court. And I remember it like it was yesterday. And the I think the difference is, where we're at now is the last move by Citizens was not to waive the provision in its policy that would allow it to go in and repair the Thorne's home. Its response was a motion for remittitor that was granted by Judge Tombrink. So we have a situation where the jury has determined that there was a breach of contract, that the breach of contract was necessitated by Citizens, and that the repair remember, there was two aspects to this case. There was the above ground, which the parties stipulated to the amount, and then there was the below ground, and the jury came back and adopted the below ground estimates that were advocated for by my clients, Mr. and Mrs. Thorne. It was then in response to that they filed the motion for remittitor, which I believe would probably be better characterized as a motion to limit the judgment to the policy limits, because there really was none of the statutory factors for remittitor that were present or argued. But in any event, the judgment was limited, and then the judge put on this performance part of it, which was you must comply, you must not only enter into a contract, enter into the same contract that they had submitted once before by Champion for the same repairs. And then, as this appeal proceeds, they then file a motion to, quote, enforce the judgment against the judgment holders by the judgment debtors, which to this day I really don't understand how that works. So we believe both orders need to be reversed, but let me get back into the questions about, in Ringelman, we made all of the arguments that we are raising here. We raised the Article 1, Section 21 argument. And I want to make sure, because I didn't really make it as clear as I need to make it in the briefs. My recollection is this Court's obligation is to avoid a constitutional question if there's any reasonable interpretation of the statutes that will allow you to do that. The only way, in my humble opinion, that you can interpret these statutes to avoid that constitutional confrontation is to do what the Supreme Court in Johnson and Werfel say: look to the title of this statute and say it doesn't apply in the litigation context.
Let me ask you,
Go ahead.
what does the policy say if the limits are exceeded by the damages?
It talks about the circumstances if the limits are exceeded by damages only in the situation where their expert chooses the method of repair, they commence the method of repair, and they then learn that they won't be able to finish the repair for the amount of the limits. Under that circumstance, they can waive the limits, or they can pay the limits without deduction for the amounts that they've already spent on the failed repair.
All right, I understand your argument that it only applies in non-litigation context, but arguably in Ringelman, we applied it in a litigation context.
As I remember the opinion, from as late as 2 hours ago, my recollection is that Citizens' attorney got up and waived the limitation for the limits during the oral argument and said for the first time, contrary to their corporate representative's testimony at trial, that they would in fact implement the repair protocol.
Right, but if it didn't apply in the litigation context, there would have been no reason for our court to have accepted that stipulation, because it's, then I think the decision would be, well, that's a nice concession and all, but it has nothing to do with this case because this is in a litigation context and the statute only applies in a non-litigation context. So I don't know what they're going to do, but if they get up on oral argument and say, we'll pay the repairs even if they exceed the policy limits, would Ringelman control?
I think there are a couple things that I might do in that circumstance, thinking ahead. The first thing I would do is to advise the court that I've already confronted my clients with that possibility, and my clients would object to it at this point. They believe, and I think we cited the court to a circuit court decision that we thought was obviously, it's not binding, but persuasive, that had some pretty good analysis about the liberty interest involved, about the ability of an insured who has an insurable interest, such as our client, that's the only reason why they get insurance, why they get to dictate what happens to the proceeds from that insurable interest, not the insurance company. And under these circumstances, we also cited the court to a supplemental authority out of the Third DCA last Friday, I believe, and I have the case back with me. But it involved a situation where it was a repair-only insurance contract, and the insurance company sought an injunction against its insureds to have the insureds execute a contract so that the insurance company could use its chosen vendor to repair the damage. And the Third DCA said, affirmed the denial of the injunction, saying, you have an adequate remedy at law, you have damages, you're not harmed by this at all. And yet we have a remedy that's been imposed on our clients that is one that is reserved when you don't have an adequate remedy at law. But we already know, and we've cited the court to the cases that say we absolutely, in a breach of contract case, as a matter of right, have a claim for damages. And so it's clear to me in going through this, and Your Honor, I know you may say, well, you know, the last panel, the Ringelman panel, by acquiescence maybe, suggested that this is a judicial issue and should be applied, but they never really squarely addressed the issue. And I know that they didn't address the issue on the constitutionality because they didn't have to. And I'm suggesting to this court that that may be one way to resolve this case without getting to the Article 1, Section 21 argument that I think is so strong in this case. Because they haven't cited you to any case that says you don't have a right to damages for a breach of contract. I mean, that's existed since the English common law. And so what is it, if you construe the statute the way citizens ask you to do so, and they have convinced the Second District to apply it, what is it exactly the effect of that? The legislature's taken away.
Well, the legislature has, for whatever, they get to determine public policy, and for whatever reason, they think, in terms of public policy, that repairing the sinkhole is more important than just letting you get your damages and go. Because people, you know, you can get an award and then you can get that money and then you can either fix your house or you can go on vacation with the money, right? But the legislature has put in the statute that in these particular types of cases, you know, there has to be a contract and then it has to be, the repairs have to be done. Why isn't that a sound public policy by the state?
I think the legislature could do that. Most respectfully, I would disagree with Your Honor that it's made its way into the statute. So the legislature has not said that insurance companies are only required to pay repairs. What they have said is in the standards for investigating sinkhole claims that this is a permissible provision that can go in a policy. But they've never said, and I know what Ms. Rockenbach has argued that against me many times. I would point out to the court that the legislative history that she cites applies a statute that's not at issue here, which is the 2011 version of the statute, not the 2009 version. But the bottom line is, even if there is a strong public policy behind it, Judge Berger, the legislature is not just free to take away that right. The legislature has got to come out and say, hey, wait a minute. We're taking away something that you've had for all these years, and we've got to give you an alternative.
Right, and let's talk about the alternative. Like workers' comp, there's an alternative.
Correct.
In this case, you know, the legislature's determined that if you don't fix sinkhole damage, it increases the risk of sinkhole damages to your neighbors. Would that be a fair statement as part of the intent that the legislature, you know, indicated behind the statute?
I don't know that that's what the legislature thought or not. I know that there are some comments in the banking committee history that's been provided. There's also, if you want to really drill down into this, you will see that this very provision that you must repair was floated and rejected by the legislature. So I think, you know, we have to go back to first, is this statute ambiguous? And that's where we get into the legislative history. The policy The public policy, however, okay, is where you're coming from. And so, yes, if they give an alternative.
You're saying
but
that they took, well, is an alternative that, they say that the insurance company either pays for the repairs, or they turn over the money. And so therefore, your damages are, you are being able to enforce your contract claim.
My contract claim has been taken away, my damages claim has been taken away.
Well,
And what I've been
a
given
repairs-only contract, a repairs-only insurance policy, for instance, you have a right to damages, but the damages are only recovered in the form of repairs. That's not unconstitutional in any way, is it?
No, I haven't briefed that issue, Your Honor, and I haven't looked at it, to be honest with you. I think the parties could contract to whatever remedies it is that they would like to contract to.
And didn't they do so in this case?
I don't believe so. I don't believe so because my clients also purchased a replacement cost policy. And a replacement cost policy is totally at odds with this provision that's in the sinkhole statute. And which, you want to talk about public policy, what's even odder is that reason, the replacement cost statute that requires that insurance companies offer that coverage came out the same year as 707, the provision that we're arguing
You have in your
about.
case a homeowner's policy. It has special provisions regarding sinkhole damage, and it says that if you have sinkhole damage, that the insurance company can require repairs be done, but if the damages exceed the policy limits, they can either have the repairs done or just tender the money. Isn't that in the policy?
It's in the policy, and Citizens did neither in this case.
Well, I understand that argument, that they're asking for a third option. But your claim that you've lost this right, or the legislature's taken away this right, or whatever, in your contract it says they have those two options. Now, I understand your argument you had in your brief that the judge kind of gave them option number 3, don't do the repairs and pay the limits.
Well, I think really where my argument was is that if you agree with me that our right to damages has been taken away, if we sue Citizens for a breach of the contract like we did here, and a jury comes back and says you're correct and your damages are X, and the judge says you can't get a money judgment, that what the legislature's given us in return for that is something that we already have had, which is a right to specific performance. So they've taken away a bedrock right and given us nothing. They've not given us an alternative. They've not provided any alternative whatsoever.
But under the contract, for breach of contract, the policy says that if you have sinkhole damages, they can either repair or tender the policy limits.
Well, this contract says they can repair using their expert, and they insisted upon that, which was the basis of the breach, and is the basis of the Blaha case, I believe, out of the 2nd District, is the one that says you can't rely upon that provision if the parties disagree as to what the proper repair protocol is. A jury gets to make that decision, not unilateral insistence by Citizens.
And the jury's made that decision here,
Correct.
that your expert's protocol is the one that should be followed.
Correct.
So if they do repairs, they have to follow that protocol, right?
If they did repairs, they'd have to follow that protocol. What they elected to do was to limit the judgment to an amount that is roughly $80,000 less than what the jury said was the damages. And then now the judge has ordered that my clients, they can't enter into a contract as it currently exists, as the judgment currently stands, that will adequately fix this house. So he has ordered them to enter.
But you didn't challenge the remittitor.
We didn't challenge it as a remittitor. They have a right to limit the judgment to the policy limits. There's no question about that. The procedural vehicle the judge used, I did have a problem on, but nobody objected to it. I agree with you, Judge Berger. But procedurally, it's the wrong way to go. It's a separate motion. The end result would be similar. But the thing that I am talking about here is now there is an order entered in place that says if you don't go enter into a repair contract that you know will not fix your house because it's $80,000 not enough, insufficient, you are in contempt of court, and I will take away your judgment.
Well, that's another issue altogether.
Well, clearly, and we've articulated this in our brief, and forgive me, I should have looked at this when we first started. I'm not sure if that 5 minutes is included on this or not.
Gave you 25, so you're
Okay.
down to 6 total.
Thank you. I'll try to wrap this up. We argued in our brief that the judge didn't have jurisdiction to enforce this judgment since the substance of the appeal dealt with the very same thing that he was trying to enforce against us. And I'll rely on the briefs on that, but I think this court,
Let me ask you this. There was a motion to enforce the judgment, but was there I'm having difficulty, and I can ask opposing counsel, with the authority, or other than the court's inherent authority to issue a sanctions order, was there a request for sanctions? Was there anything like that, or was it just?
that's their motion. I'm sure Ms. Rockenbach will be able to articulate all of that for you, but yes, it was enter into a repair contract now, no offer that it would be for whatever, whatever the cost, whatever it took to repair. Enter into the repair contract now, and if not, we want sanctions, and we want the judge was threatening to take away the judgment that our clients had obtained after a jury trial, because we wouldn't enter into this contract. So let me kind of try to first ask if you have any more questions of me. If not, let me just kind of wrap some of this up a little bit. And I'll stand on the briefs to the extent that I haven't really articulated all the reasons why we think that this violates a variety of our clients' constitutional rights, not the least of which is the access to courts. There's the Article 1, Section 10 argument based on the Searcy case that this application of the statute to my client's replacement cost policy severely diminishes the value of that contract and therefore is contrary to the Constitution. We've put in the due process and the equal protection as well. I want to also get back to one other thing, which is
You're down to 4 minutes.
I know, but
Okay.
I have to bring this
I'll
point
make
up.
sure. Go ahead.
In the Blaha case, the Second District said when they were addressing this notion that the breaching party waives subsequent performance by the non-breaching party, the court cited to the Florida Supreme Court case in 6Ls. 6Ls is a coverage by estoppel case. It has nothing whatsoever to do with a breaching party and the effect of that breach on the non-breaching party's subsequent duties. So I would ask the court to take a very careful look at the thought process that went behind that part of that decision. Thank you.
Good morning. May it please the court, Kara Rockenbach on behalf of Citizens Property Insurance Corporation. It is a public policy safety issue that is pending before this court, the same as the one that was in State Farm versus Phillips, which Judge Evander, you were on that panel. Judge Berger, you were absolutely correct. It is squarely on point. The only distinction between this case and the State Farm versus Phillips case was that that was an appraisal. But the same issue.
Let me ask you this. You know, the Phillips case and the second DCA cases, the damages were less than the policy limits.
Correct.
So in a way, that makes it easy. Here, the policy limit, the damages found by the jury exceed the policy limits. Both the statute and the policy, and correct me if I'm wrong, say that at this point, you have two options.
Correct.
Did the trial judge here kind of give a third option?
No, Your Honor. And let me.
Are you willing to, you know, the jury protocol, what the proper protocol the jury found was going to cost a lot more than what your experts said?
Well, here's the interesting thing about this case. I am authorized by my client to be bound by my statement today, the same as appellate counsel for Citizens in Ringleman. We will pay the actual cost. We want the repair contract consistent with what the jury rendered. The jury found the necessary repair. We will get it done. What we don't want is the cash payout, because that's not what the legislature intended. The legislative intent, and you, by the way, can't just look at the title of the statute, because this clearly governs the entire sinkhole process, and it is a statutory scheme work, that the legislative intent was, and I quote from the history, "The legislature finds that losses associated with sinkhole claims adversely affect public health, safety, and welfare of this state and its citizens." So therefore, unlike fire or water or hurricane, this is a provision in the policy that mirrors 627.707, subparagraph 5, that requires one condition before you get your insurance policy payment, dollars. Enter into a repair contract. In this case, just to discuss numbers for a minute, the jury pulled 300 out of the air. It was a very odd verdict. As this court knows, we dismissed our main appeal, despite many legal issues that could have been raised, because citizens really wanted to go back down, enforce the jury's verdict and the repair contract statute, and get it done. The plaintiff's expert under oath testified, this is a sinkhole loss, and it's dangerous. Citizens was actually the entity and its citizens expert who found it to be sinkhole before anybody did.
Let me ask you this. With regard to the scope of the work, was there a
Yes.
difference in the scope of the work in the plaintiff's expert's report and in your expert report?
Yes, Your Honor, as well as the neutral evaluator in this case. So
Okay.
let me go to the numbers. 100 was citizens expert. They come in a year later, and Champion says for the plaintiff, we can get it done for a range, because we know that there's no finite number. The ground takes what the ground will take. And these contractors are guessing at these numbers. So the plaintiff's expert said 219 to 230, and did have additional, I think it's.
But as a practical matter, how does the trial judge, based on, your statement, what your client's willing to do,
Yes.
how does the trial judge or our court in opinion make sure that the scope of the work that's done is consistent with the
the
plaintiff's
jury.
expert based on the jury's finding?
The final judgment, Your Honor, I think addresses that. Let me just pull it for the court. And for your edification, Citizens is already bound by excess policy limits, because in addition to the 220,500 policy limits for the subsurface, they were ordered to and did reissue the check for the above-ground damages for $34,000, and that's in the final judgment. Your Honor asked the question, how do we make sure that Citizens, well, I'm bound by my statement, my client is bound by my statement here today, which is consistent with Ringelman, what we did there.
But there's a difference between saying we'll do the repairs and saying
Right.
we'll do the repairs consistent with the scope of work recommended by the defense expert, or we'll do the repairs pursuant to the scope of the work as recommended by the plaintiff's expert.
Right. I was just looking.
So is your agreement that your client will do the repair, the scope of the work, will pay for the repairs, even if it exceeds policy limits, consistent with the scope of the work set forth by the plaintiff's expert, which was apparently accepted
What the
by the
jury accepted. That's correct. That is correct. We had to reduce it to the policy limits because, well, as counsel conceded, that's the law. And also, if, by chance, when they start pumping grout into the ground, doing the underpinnings, and the ground only takes $150,000 worth of chemical compaction and grout and underpinning, then there shouldn't be a surplus that is left above the policy limits. So we reduced it to the 220,500 because that is the law. Those are the policy limits. We're willing to do more. We do still have, under the statute, the ability, if it's $1 million and the ground just simply can't be fixed, then we can tender the 220,500. That's the or in the statute as well as in our policy. If it turned out to be $1 million fix and the property was condemned, I don't believe the plaintiff would want to fix it. But it begs the question, because it's the plaintiff who brought the action and said, dangerous sinkhole. Why wouldn't they want to repair it and enter into a contract consistent with the jury's verdict up to the policy limits? And they can enter into a contract that says up to the policy limits. It does not require them to come out of pocket whatsoever. And my client is willing to get it done for what it will take, what the actual cost
Did
is.
your client say that at the time of the entry of the final judgment, or did you put it in your briefs? That
There is a
you wanted to do
motion.
that? Or is this the first time we're hearing this?
I would submit to the court that it is not the first
I
time.
know
And-
you did a motion to enforce prior to trial.
Correct.
But you didn't have a jury decision on what the scope of the work would be.
Right, and there's a retired judge from Hernando, Honorable Stanley Mills, who used to say, back when I started doing sinkhole 5-6 years ago, he'd say these really shouldn't be breach of contract actions, they should be method of repair declaratory relief actions, which makes sense, because at the end of the day, you just want the jury to decide which method is the necessary method. It doesn't have to do with the dollar sign. There's a contractual requirement that we pay to fix the land or dump the policy limits, either or. So in this case, there was the motion to enforce, which says that we will, I believe it was consistent with what we were doing at that time.
End up with the sanctions. How do we end up
Yeah.
with, you don't do it within 90 days, you're not getting anything?
Okay, so the statute, believe it or not, has a procedural mechanism now, today, not the 2009 statute. The new statute, after 2011, when the law has changed, legislature keeps trying to fix the sinkhole mess, saying, we've got to repair the land. It's a public safety hazard. So they implement new changes. To 627.707, subparagraph 5B, there is now a requirement, and it's significant, that the insured enter into a repair contract within 90 days after the insurance company confirms coverage, which would be by a jury verdict. You have a verdict that says, here's what you owe, here's the necessary method of repair. So in candor to this court, that new statute was not argued below. It wasn't raised by me in the brief. However, it is the law at the time that
Could the
motion
trial
to-
judge have vacated the final judgment if we hadn't entered a stay?
We did not oppose the stay. We did not oppose the motion that came up to this court asking for the
But
stay.
the trial judge refused to stay.
He
We
did.
granted it.
That's correct.
If the trial judge hadn't entered the stay, can a trial judge vacate a final judgment while that final judgment is on appeal?
Well, the rule is that he cannot alter the substance. He can't issue a satisfaction of the judgment and can't alter the substance, but he
Wouldn't
can.
vacating be altering the substance?
I think vacating would probably be altering the substance. However, it was stayed. So where this court is now placed is, and Citizens has no issue with the affirmance of the requirement to enter into a repair contract and the extension of an additional 30 days after this court affirms that for them to enter into a repair contract. The goal here is to repair the land, and that has been my client's consistent request.
Well, let me ask about jurisdiction for the trial court to do what the trial court did. You know, if the appellate court was to agree with your opposing counsel's argument on appeal in its entirety, and the party had followed the trial court's motion to enforce, we'd have a third person with an enforceable contractual right. Where would that leave us?
A third person with a
Or,
contractual,
you know, if they entered
The-
into a new contract
the contractor?
with the contractor,
Right.
and then we reversed for whatever reason, that new contractor still has a right to enforce the contract.
Well, the order that the court entered on the motion to enforce compliance with final judgment actually was, it was not an automatic, it was a show cause. It did not say you're going to lose your judgment. It
First thing
gave,
it did, though, was order the
Third-
plaintiff to enter into a contract.
correct. And they had 30 days. And then,
So if they had entered a contract consistent with the motion to enforce,
Mm-hmm.
and then they won on appeal, then they're sitting there liable to that contractor.
there are so many ways to nuance that contract, Your Honor, which is enter into a contract subject to, and they can preserve their right to come up here, but the contract would require the repair consistent with the jury verdict.
The order
Sub-
didn't say that. The trial judge's order say, enter into this contract for repairs within 30 days or face the risk of having the final judgment vacated.
Or show cause within 45. And so they could enter into a contract. The order did not come up with creative ways to enter into a contract. But
I'm just baffled by why y'all would file that and why the trial judge would enter that.
well,
I mean, because
the
why are
time,
we sitting here as an appellate court if the judgment's going to disappear or a third party's going to be brought in, I mean, where does that leave us?
The timing of...
Appellate court.
Right, and I understand, Your Honor, there is concurrent jurisdiction under 9.600. However, your point about impacting a third party was obviously not contemplated, raised, or argued below. The timing of that motion to enforce the final judgment in the context was several things. Citizens had dropped its main appeal, which involved juror nondisclosure and the different issues that could have been raised. So it was in the context of that. There was an appellate mediation I saw in the motion to enforce. So the context was citizens moving forward saying, please enter into a repair contract consistent with the jury verdict. So I suggest to the court that there were ways to do that, comply with the trial court's order within the 30 days, or come in before 45 days pursuant to the order to enforce and say, I don't want to sign the contract because it will implicate rights of a third party, or I'd like to sign a contract, may I make it contingent upon the 5th DCA affirming my appeal, or there are multiple ways the insured could come back before that court.
It was your motion to enforce.
It was.
You asked the judge to enter
You're
that
correct. It was ours.
order. And that order says, you agree that the trial court doesn't have jurisdiction to vacate the final judgment.
It does not have jurisdiction to
Well, then does it have
substantively
jurisdiction to enter an order to say, if you don't do this, I'm probably going to vacate the final judgment? Or that's a threat. Does it have jurisdiction to enter that type of order?
Well, that part never came. That never came because the order to show cause, no less than 45 days of this order, never occurred. Although the judge below denied the stay, appellant appropriately moved this court to stay. And they had alternatives. They could have gone back before the trial judge and said, instead of staying this order, can we enter into a contract contingent upon the 5th DCA, which is the one that I keep saying makes the most sense.
Well, leaving aside the stay factor, was the judge's order an error?
The judge's order is not in error. The judge's order,
Threatening to vacate the final judgment while the case is on appeal and ordering the party to sign a contract with the third party before we rule, you're saying that was a proper exercise of authority and jurisdiction by the trial court?
at that point in time, yes, because then it is stayed and the appellant has the full opportunity to be heard by this court, and we did not oppose.
Only because we granted the stay.
You did grant the stay,
Of
and
course, when the trial judge entered the order, he doesn't know if we're going to grant the stay or not. In fact, the trial court denied the stay.
he did deny the stay.
If
And
we
then
hadn't stepped into that time, would it have been error?
at that time, it was not error. It might be different if the court went forward with 45 days from then and they did not move for a stay up here. And
Citizens opposed the stay at the trial court level?
yes, but not on this, not at this court. Not at this court. And I think we worked with counsel to consolidate the appeals so that the issues could be combined. We asked this court to recognize, as it has done, not just once but twice, State Farm versus Phillips and the Ringelman case, that the legislative intent of the sinkhole statutes is to repair the land. My client clearly had a dispute over the method of repair, and there were three disputes, or three types of repairs that could have occurred, with the neutral evaluator having a different one. All of them were within the range of, the highest was 230,000. And so the reduction of policy limits was appropriate. And by the way, we talked just briefly about constitutionality, and I set forth in my briefs that these issues were not preserved. There was one word, unconstitutional, in one motion below, but due process, equal protection, and the right of access to the courts were three concepts that were never, ever argued below by the appellant, and so they're not here before this court. We ask that this court follow the body of law in Florida, consistent with its own 2 decisions and at least 5 out of the 2nd DCA, which have been, 3 of which have been reviewed, denied by the Florida Supreme Court on jurisdiction with regard to the constitutional issues that were argued. We ask that you affirm both orders, and unless there are any other questions. No.
right, thank you.
Thank you.
So thank you for the confession of judgment. But a couple things I think we need to address here. If the court is willing to accept this late offer to waive the policy limits. I know in the Ringelman case, when that occurred, the panel then viewed that as no reason to reverse, did not really address the change in position, and denied Mr. Ringelman any attorney's fees whatsoever, notwithstanding the fact that by virtue of the confession of judgment that occurred in front of this court, Mr. Ringelman received more than double the limits of what his policy was. So I would ask the court to be mindful of that, or keep that in the back of the court's mind.
Let me ask you, given what's happened here today, are we in the Ringelman situation? Is there any
We
difference?
sure seem
Any
to be
difference
in a very similar part of the situation. I would ask, however, this needs to be resolved, this issue about whether 707 subsection 5 applies to judgments.
Did you raise that issue in Ringelman?
I didn't ask the court to certify the question in Engelman. In Ringelman, I am going to ask the court to certify the question here. We can kind of dance around this all we want, and there's been a lot of dancing going on, in my humble opinion, trying to explain jurisdiction to enforce a judgment that's on appeal, clearly the terms of which are the ones that are the subject of the appeal that would have made our appeal moot had the judge enforced it. But I think this needs to be answered, and it needs to be answered by the highest court of the state. We keep coming back to this over and over and over again. And so these clients have been run through, I mean, they're stuck with this adverse event, an act of God, that impacts their major asset. And rather, she wants to talk about fix. What the purpose behind this statute about the investigation of sinkholes is to make that process quick, is to make that process efficient, to make
Would it
it...
be efficient if we wouldn't be here if the Thornes had entered into a contract?
They did. They submitted it, and they rejected it. They submitted a contract for the very repairs the jury said that was necessary in order to repair. What they didn't do was enter into a contract for inadequate repairs, which is what they demanded. And so now what they've said, and I still don't know if you got an answer to your question, Judge Evander, about are they saying that the judgment limits now come off and they will pay no matter what it costs to effectuate our experts' repair protocol?
I think they said they'd
That's how I
pay
took
up
it.
to what the jury's verdict was, which was, what, 300?
300,000. Well, in that case, and I need to wrap it up. I see I'm over my time. We would ask that the court certify the question in the Florida Supreme Court irrespective. We would also ask that the court reverse the sanctions order that was entered. So in the event that the court does give us the opportunity to go to Tallahassee to get an answer on this once and for all, we're not held in contempt again. Thank you.
Thank you.